Hello and good day to everyone. I'm Brian Patterson. This is ENS, and today we are discussing data privacy in the workplace, an African perspective. Data privacy in the workplace is no longer a technical concern. It's become a fundamental business and ethical concern. And I think, as we all know, it's now central to ESG compliance and is one of the fundamental pillars. It impacts upon a company's reputation and arguably, with many of the fines that are being imposed internationally, on the bottom line too. Now, where does privacy come from? And without going into great detail, I think historically, most common law and Roman Dutch and English jurisdictions, upon which many legal systems are based, has provided for privacy by means of the law of tort or the law of delict. And those enforcement provisions have largely been inadequate. So in 1995, the European Union adopted the Data Protection Directive. And if one thinks back to 1995, that was at a time that the internet was in its infancy. And those provisions have guided most jurisdictions since their inception. And then in 2016, quite a seminal moment for privacy law, the EU adopted the General Data Protection Regulations, the so-called GDPR, which I'm sure everyone's familiar with. And that arguably has been one of the greatest achievements of the EU in recent years. And I think to a large extent that the GDPR provisions have spawned the privacy protections in most jurisdictions, and more particularly many of the African jurisdictions. But one has to be careful because, as you'll see today, all of the jurisdictions we're going to deal with have nuanced and very important distinctions between privacy law in those jurisdictions and GDPR. So today I'm joined by 7 guest panelists. They're all experts in privacy law. They come from ENS offices in Ghana, Kenya, Mauritius, Namibia, Rwanda, South Africa, and Uganda. And they're going to unpack privacy law and what it means in these jurisdictions. And also, we're hoping not to repeat too much, but to show the fine, nuanced distinctions between these jurisdictions in respect of how privacy is given effect to. So I'm going to initially start with some quick fire questions. Without any further ado, I'm going to go to the panel. So we'll start with Patricia Mamuni from Ghana. Morning, Patricia.
Hi, Brian.
How are you today?
I'm well, thank you. And hello to everyone.
And how is Ghana?
Ghana is fine. The weather is nice.
Awesome. Okay. The weather's always nice in the African continent. It's one of our great strengths, isn't it?
Yes, yes.
No. So far as Ghana is concerned, just quick fire questions. Do you have data privacy legislation? What is enforced and since when?
We do have data protection legislation. It's called the Data Protection Act. It was passed in 2012 and is largely based on the GDPR. And at the time, the EU directive, which was replaced by the GDPR.
In fact, you were ahead of South Africa because I think our legislation came in 2013. So that must have been the EU directives, as you pointed out. And how similar is it to the GDPR? We'll come to the detail later, but is it very? Would someone who knows GDPR be familiar with it?
Yes, it's largely, so our law was largely based on the EU directives at the time. And so you realize that a lot of it, about 95%, like the GDPR. A few nuances here and there, nothing major, but if you look at, once you comply with our Ghana Data Protection Act, you have complied with GDPR.
And I think most of our viewers will be asking the question with jurisdictional companies based in London, New York, Europe. And I see we've got over 300 viewers, many not only from the African continent, but from Europe and States. They're going to want to know about cross-border protection of information. What are the requirements? Is there safe harbor? And what's the position in respect of fines if you fail to comply?
So first of all, Ghana is not a party to any safe harbor agreements. In relation to the transfer of data, there are a few key things that our clients ought to know. One of them is that if they want to transfer data, the data subjects must be aware of the transfer. There's also a requirement to notify the Data Protection Commission, and this notification is usually done at the time of registration or the time of renewal. If you are not able to do it at the time of registration or renewal, then you have to inform the Data Protection Commission at the time of the transfer. Another key thing to note is the fact that if you have a third-party processor, you have to have an agreement with that third-party processor, whether it's a data processing agreement or a data transfer agreement. Any form of agreement to record the terms of your agreement must be in place. These are the key things that are relevant to data transfer in Ghana.
Thanks, Patricia. We're going to come back to you shortly on some of the more important distinctions between GDPR and the South African position and the Ghanaian position. Now, if we can move to Dennis Katara of Kenya. Good morning, or good afternoon, Dennis, I should say.
Hi, Brian. How are you? It's afternoon here in Nairobi.
I'm very well. The weather is also good in Nairobi, I have little doubt.
It is.
All right. Data protection in Kenya. Do you have something akin to GDPR?
Yeah. The conversation in Kenya started around 2013, but we got around to passing the statute in 2019. So we have what is called the Data Protection Act. And that act is actually supplemented by various regulations and various guidelines that have been passed by the Kenyan government. And essentially, this is the law that governs data privacy in Kenya. That's also anchored within the Constitution of Kenya.
Great. And what do you do in respect of cross-border transfer of information? If we have clients in London or New York, and they have an operation in Kenya and they want to share data with their group offices, what's the position in Kenya?
Yeah, so our laws are quite new, so we are still waiting to see whether the regulator will issue any adequacy decisions. But in terms of transfer at the moment, you have 4 conditions which would allow you to transfer. Where you have adequate safeguards in place, then you can transfer personal data outside Kenya. There is also an adequacy decision issued by the regulator. At this moment in time, the regulator has not issued any adequacy decisions, but it's worth noting that any signatory to the African AU Convention on Cybersecurity and Protection of Personal Data is considered an adequate jurisdiction. There's also necessity and consent of the data subject. So where those situations exist, you can transfer data outside Kenya.
And I assume it's always good in these instances to ensure you have consent if you can get it.
Indeed, it's required. It's not mandatory, but it's a good thing to have. If you have the consent of the data subject, then it makes the conversation quite easy.
Good. What happens if a Kenyan company breaches the data protection laws in Kenya? What sort of penalties are likely to be imposed?
Yeah, so as far as the sanctions are concerned, you can be fined up to Kenya shillings 5 million, which is around 30,000 USD, or you can have a situation where criminal sanctions may be imposed upon you up to Kenya shillings 3 million, which is about 20,000 USD, or imprisonment for up to 10 years. It's highly unlikely that the custodial sentences will be implemented, but we have seen the regulator imposing fines on institutions that have violated the statute.
And is the liability an individual one, or does it extend to juristic persons, corporations, and the like?
So in terms of liability, it would extend to juristic persons, but the law itself only applies to natural persons. So the DPA only applies to natural persons, but in terms of fines, you may find even juristic persons being fined.
Well, thanks very much for that useful review. Over now to Mauritius and Harry van Swopen. Harry, are you there this morning?
Hi, Brian. Yes, I am
I'm
here.
delighted to see, Harry, you're not on the beach. Whenever I'm in Mauritius, everyone wants to be on the beach. Is the weather good in Mauritius?
It is perfect today.
It always is, isn't it?
Yes, it is.
Tell us, Harry, about protection of privacy and data in Mauritius. Do you have something akin to GDPR?
Yes, we do since 2018, January 2018, but we did have Data Protection Act since 2007. Then with GDPR, we aligned with Europe nearly immediately after they passed GDPR in 2016. It was supposed to come into force in May. By that time, we already had a Data Protection Act, which was in force. Although we passed the legislation in 2018, the jurisdiction is still complying. It's still in its, let's say, infancy stage. The data commissioner is still providing for educational sessions so that everybody complies with the exigencies of the new law.
Now, Harry, Mauritius, as I recall, is one of those jurisdictions that is English common law and French law. Does that impact at all on the sort of GDPR? Are you more aligned to the to one or the other in this regard?
It follows the GDPR from Europe, and it aligns completely with the GDPR. With regards to interpretation, some matters which have not been defined by or in the Data Protection Act, we would tend to go to these jurisdictions, guidelines, and interpretations. So yes, from time to time, we may turn to the CNIL, which is the authority for France, or to the ICO for the guidelines issued by the English when our regulator hasn't issued any guideline or there's no definition in our law.
Yeah, sorry, go ahead.
Brian, one good example would be legitimate interest. This is where there's no definition as such, and we may turn to these jurisdictions for interpretation.
Thank you. And insofar as protection of employees' personal information on cross-border transfers, which is such a big issue for many of our international clients with group companies in other jurisdictions, what's the position that you adopt there in respect of transfer of information?
The position, if we adopt a literal interpretation of our law on transfer of data to a foreign jurisdiction, you would obtain an either-or situation. Either you go to the data commissioner and prove appropriate safeguards, or you rely on the legal basis which is available, i.e., if there is a contract, it will have to be necessary for the performance of a contract or for the conclusion of a contract to transfer the data. If there is no contract available, then you will have to obtain explicit consent from the data subject. It's either or. or if none of these are available, then you have to show that there is a compelling legitimate interest. And some
as a general proposition with clients, again, and we discussed this a little earlier, consent seems to be a good idea when it comes to data, as long as it's proper consent. Do you go along with that?
Yes and no. It depends. If you can have a contract, in some aspects, consent may be advisable. In some other aspects, consent may become very heavy and very burdensome, because your data subject can revoke consent at any given time. So if you are in a situation where you wouldn't want consent to be revoked at any given time by the data subject, or it may be burdensome for you to collect consent on an individual basis, then contract may be advisable. Or in some other situations, legitimate interest may be advisable.
Yeah. Maybe I see we have a question from one of our viewers in Mauritius, so let me put it to you quickly. We will be coming back to you, of course. The question is, are you recognized under GDPR as one of the countries where you are allowed to share data as if it was in the EU, or is it not? If you would have to do an analysis and determine if the data is allowed to be transferred cross-border. So do you adopt the EU position, or are you different in that regard?
We adopt the Data Protection Act position, which to a large extent is aligned to the EU GDPR.
Okay. I'll put that viewer in touch with you. Thank you, Harry. If we could move now to Ray Wood, Rukoro of beautiful Namibia. Ray Wood, where are you joining us from today?
Yes, I'm joining you. Hi, Brian. I'm joining you from Walvis Bay at the coast of Namibia.
One of my favorite places, also great weather.
Yes, great weather, a bit cold and windy, but otherwise there is a bit of sun, so it's good. Yes. Good.
So tell us about privacy and GDPR in Namibia. Is it similar to the South African position? Is it and the GDPR position? Is it different? I know there's a historical link between Namibia and South Africa, so there's often similarities.
Yes. Namibia does not have any data privacy laws or legislation in place. There is presently a draft being circulated on the data protection, but by and large, we rely basically on what is contained in the Namibian constitution, where the right to privacy is protected as one of the fundamental rights. We also borrow generously from South Africa in many respects, because most of the entities that operate here are also have a heavy presence in South Africa, and in some instances are headquartered there. So they have a backdoor approach to applying data protection rules and laws from South Africa. But other than that, we don't have a specific provision in our law, but there is development in that regard.
I assume, looking at the legislation in the pipeline, that consent and the general international principles would probably be a good starting point to protect yourself in Namibia.
Yes, that's correct, Brian. In fact, we borrow generously from the GDPR, and also the consent is paramount, and also the issue pertaining to cross-border sharing of data. There must be consent, and secondly, it seems as if Namibia draws back a little bit and say, wait, there are two. You must guarantee that there is no harm being done, firstly, to the individual, and secondly, that the laws of the country to which the data is being transferred must be complied with the data protection laws.
Raywood, do you currently have, one of the questions that's also been asked by one of our viewers is, do you have a regulator in Namibia or a regulator function where breaches are reported, or is that something that will be provided in the legislation which is in the pipeline, so to speak?
Yes, we don't have at the moment, but yes, a large part of the legislation provides for a regulatory authority that will be looking, and it sets out the different powers. I mean, it would be futile to say what those powers are now, but it will come, once it comes into force, we will expand and deliberate on it. At this stage, it's still in its infancy.
So if I'm sitting in Namibia and I apply for a job and I'm object to you looking at my criminal record, which I think is irrelevant and to the job. If I was to seek protection, I'd have to come to enforce my rights in terms of the Constitution at this stage, but that's likely to change soon.
Yes, that's correct, and it's likely to change. But also, there is quite a drive from it is required of every employer that requires information, especially pertaining to criminal records and so on, that it should be for a legitimate purpose and that it should be in furtherance of the business interest. And it's not just something that you willy-nilly can request and ask or disseminate.
All right. I see there's a further question. Namibia seems to be very popular this morning in questions, so you're obviously a lot of interest in privacy in Namibia. Our viewer says that their company has a number of German citizens, lots of German citizens in Namibia. And although GDPR is not applicable insofar as it is in the EU, would you implement GDPR on those citizens? Is there any Namibian law that applies, or would you just do something akin to GDPR? I mean, is it technically applicable in Namibia, whether the citizen is German or otherwise? Does it matter the citizenship of the person?
Well, citizenship of a person would not matter. At the moment, they will receive equal protection in our law, and they would enforce any other rights that also other citizens would enforce if there is a breach. And our courts would adjudicate not on basis of nationality, but on the basis of the actual breach that's brought before the forum to adjudicate.
So your privacy rights are constitutionally protected, and your citizenship is absolutely irrelevant. That's what I hear you say.
Yes, that's exactly what I'm saying.
Ray Wood, thank you for that very illuminating review of the Namibian position. We're moving now to Rwanda and Jean-Claude Kabira. Are you there, Jean-Claude?
I'm there, Brian.
And Jean-Claude, what's the position in Rwanda in respect of enforcement of privacy? Do you have something similar to GDPR?
Thank you, Brian. Our Data Protection Act has some similarities with the GDPR, but there are also some key differences, whereby the breach notification for GDPR, the notification is done within 72 hours, while for Rwanda, the breach notification is done within 48 hours. So another key element of a difference resides on the transfer of information of the data, whereby in Rwanda, you cannot transfer information without authorization from the supervisory authority. In this case, it is National Cybersecurity Authority. And you have to secure data subject to consent and assure the necessity of transfer.
I'm going to Jean-Claude, if I may. I'm going to come to some of the detail shortly. Just as a general proposition, if I'm in Rwanda and I am an international company and I want to transfer data to my head office in France or elsewhere, are there any specific provisions that apply in respect of cross-border transfers?
Exactly. It is there, but you must prove the necessity of the transfer of that information. So when you want to set up a subsidiary, for example, so if you were able to prove that, so the supervisory authority authorize you to go and transfer such information.
Thank you. Now, Jean-Claude, if I were to be in breach of the Rwanda data protection legislation, what is the penalty and how seriously are these things enforced?
Yeah, there are some penalties, but they are arranged from administrative fines and penalties, which goes with the criminal offenses. For administrative fine, they are ranged from 2 million francs. It means $2,000 to $5. When it comes to imprisonment or penalties, a person may be sentenced to from 1 year to 10 years. While for the corporation, it may be fined 1% of the turnover of the previous financial year.
Let me just see if there's anything specific that's come up. I'm going to come back to you in due course on some of the questions that have arisen. We now, thank you very much, Jean-Claude. We now are moving to Samaya Hanif in beautiful Johannesburg, South Africa. Good morning, Samaya.
Hi, good afternoon, Brian, and everyone on
good afternoon.
Webinar.
Yeah. Hi, Samaya. Samaya, we're going to come into some detail a little later with you, but for now, if you could just tell us, is there data protection legislation in South Africa?
Yes, there is. It's fully in effect from 1 July 2021, and it's called the Protection of Personal Information Act, commonly referred to as POPIA.
And so go ahead.
Yeah, I just wanted to say this act was a draft in 2013. So similar to all of my colleagues, similar time frames that we're looking at.
Yeah, I actually find that interesting because just as one of our colleagues indicated, it was drafted based on the, before GDPR came in, based on the European Union directive. So it was one of the early pieces of legislation, but it took forever, if I recall, for it to in fact come into force and effect in South Africa.
That's great. And it's really, modeled on the GDPR to a large extent. But there's, one specific difference. The definition of data subjects is much broader in POPIA than it is in GDPR because it covers juristic persons, whereas GDPR doesn't.
Yeah. Well, we're going to come back to that because that is a really significant legal and practical distinction. Samaya, how does one deal with the cross-border transfer provision with international corporations located in European or US or cities that have head offices and want to transfer information concerning employees in South Africa?
Yeah, so in terms of POPIA, it's quite similar to what some of my colleagues have mentioned. The jurisdiction that's receiving the information must be subject to a law or binding corporate rules or an agreement that provides adequate protection. When you talk about adequate protection, it's protection that is similar to that offered by or provided in terms of POPIA. And in the event that there isn't a data privacy legislation in these jurisdictions or inadequate protection is offered, then obviously consent is what you can rely on. And in terms of POPIA, it must be specific, informed, and voluntary. The data subject must consent. If not, then some of my colleagues have also mentioned if it's necessary to give effect to a contract between the data subject and the responsible party, or between the responsible party and a third party, provided it's for the interest of the data subject, then it may be transferred to the other jurisdiction.
Now, again, I know you're going to tell us of some anecdotal cases later or refer to them in South Africa, but how vigilant is the regulator and what are the possible penalties for failure to comply in South Africa?
Yeah, the information regulator in South Africa is actually playing a very active role. So for breaches of POPIA, there must be a distinction between breaches, because that's where the information regulator will issue an enforcement notice and may institute civil proceedings against the responsible party on behalf of the data subject. Where there's an offense, for instance, there is no compliance with the enforcement notice, or there's interference with the investigation or with a warrant of information regulator, then a fine can be imposed of up to 10 million rand, or imprisonment, or both. Imprisonment is up to 12 months. Yeah.
Okay. So the South Africans are taking it fairly seriously. I'm going to come back to some details shortly. Just quickly, thank you, Samir. If I can move to Rahima Samyalo in Uganda. Rahima, good morning or good afternoon to you.
Hi, Brian. Good afternoon.
Sorry, I apologize. I'm sitting in New York City, so it's morning here, so I keep on saying good morning. Can you tell us, is there GDPR in Uganda or something akin to it?
Yeah, so first of our constitution guarantees the right to privacy. And I think in 2015, discussions around drafting a comprehensive law on data protection started, and the law was finally passed in April 2019. And then regulations to give effect to the law were published in July 2021. So yes, we have a comprehensive law on data privacy, and I think, like everybody else has mentioned, it's modeled to a very large extent to the GDPR.
Okay. And what happens in respect of cross-border transfers? Is there anything specific in Uganda that needs to be done on cross-border transfers?
Yes, so two things. First off, the data processor or data collector must ensure that the other country to which personal data is going to be transferred has in place adequate measures similar to those provided under the DPPA. So adequate measures relating to protection of personal data. And at the point of registration as a data processor or data controller, the applicant is required to give an undertaking to our regulator that they'll ensure that the other country to which data is being transferred has those measures in place. But I think that the unique thing about Uganda is that it's a self-assessment model. So that data processor and the data collector for now would have to make a self-assessment on the adequacy. The regulations empower or would require the regulator to publish in the Gazette what countries the regulator deems have in place adequate measures. But for now, that list is not yet out. So the position currently is that you make your own assessment about the adequacy of the protections in the other country that the data is going to be transferred to. Then, of course, the second point is consent. So it's either adequacy or you have to obtain the consent of the data subject.
Thanks, Rahima, for that. Just finally, how vigilant is the regulator, and what sort of fines can one expect if you fail to comply in Uganda?
Yeah, so our regulator is very active. They were set up in 2021, and they started off with just trying to sensitize the market, just to get everybody aware about data protection and privacy. And to date, I listened to an interview that the regulator gave to a certain podcast, and she mentioned that they'd received over 1,000 complaints around data breaches, but they've only published one. They've only managed to investigate and publish only a single report when it comes to a data breach. And I think also that the difference with our regulator is that they don't have powers to impose penalties. So they made a finding in this case that indeed there'd been a data breach, but that's as far as they go. When it comes to actually enforcing penalties, they'll need to then either prosecute or bring civil proceedings against the offending data collector or data processor. And maybe just to touch on the quantum of the penalties that are imposed under the DPPA. The DPPA provides a fine of up to 2% of the gross annual turnover of the offending data processor or data collector. We also have prison sentences of up to 3 months, 6 months, or 10 years, depending on the breach that's being committed.
My goodness. All right. Well, thanks, Rahima. That brings us to the end of the first part of the webinar today. And what we're going to do now is I'm going to go back to Samaya Hanif in South Africa, who has a significant privacy or privacy, depending on your pronunciation practice, and ask Samaya just to deal with some of the key areas in respect of compliance and practically where this manifests itself and generally the approaches. Then we're going to go around the panel and ask the various panelists in the other countries concerned to tell us how they would differ. So we're only going to look at the differences, and then we'll finish with some Q&A. Samaya?
Thanks, Brian. So I mean, in the improvement
before you start, just to
yes.
get you off beat, we have a question from one of our listeners or viewers. First of all, one viewer says the audio is bad. That's been drawn to the attention of the technical people, and they're looking into it. Maybe at your side, if anyone else is experiencing bad audio, please let us know. But the question's an interesting one, and it basically is this. Do you think that the African Union missed a beat by not adopting a regional data protection framework, allowing African continental businesses to comply with common data protection rules throughout the African continent, rather than the proliferation of very similar but nuanced different legislation? Was that a missed opportunity, Samaya, do you think, from an African continental perspective?
In my view, I think it is. I think that we have so many similarities, as you can hear, in terms of how we deal with data privacy. And it would be nice if we could, instead of referring to the EU GDPR laws, regulations, have something that's African-based. Yes, I think that was a missed opportunity.
Yeah, and one of our viewers just wants to clarify in South Africa on imprisonment for papier. The viewer points out it can be up to 10 years, depending. That's Section 107 of the Act. What is the position on imprisonment?
Yeah, so there is a period of 12 months has been referred to, but yes, there is a discretion that it can be up to 10 years.
Presumably that'd be for very serious.
Depends on the nature of the offence. Yeah.
So if you could briefly just tell us what are the key factors, and where in your daily practice, where does this arise? What's the where is this proving to be creating mischief amongst our clients? Where and what are the approaches?
Okay, so we are advising clients in terms of a number of scenarios, and I'd like to separate them into different categories. So when we're dealing with pre-employment, we have a situation where we have job applicants and the information that they provide to potential employers in the workplace, and how we deal with that. So often the question arises, what can a prospective employer conduct background checks? And the answer to that is yes. And consent is first prize, but in the event of no consent, you can rely on the legitimate interests of the employer, which is to determine the suitability of candidates. Then flowing from that, Brian, the next question would be, what about criminal background checks? Is that permissible? And, interestingly, Popia distinguishes between criminal history, which is actual convictions, where a person has been found guilty and sentenced, and then criminal behavior, where there's allegations pending. So when it's criminal history, then you can process that information provided the employee gives you consent, and you can rely on the legitimate interests of the employer as well, because it would be dependent on the inherent requirements of the position. So, for example, if you have someone who's committed fraud or corruption, found guilty of it, and he's being or she's being employed in a financial in the financial department, for example, you may want to obtain that information, and obviously that will determine whether you appoint that person or not. But criminal behavior, where you're not found guilty because it's sensitive and could be prejudicial to the data subject, it's called what we call a special personal information. Their consent would ideally be the only way you would be able to process that information. You can't rely on legitimate interests of employer there because of the sensitivity of it.
Would you obtain that consent through a pre-employment form or document that the employee would have to complete to be considered?
Yeah, so job applicants will be required to complete a consent form where they agree to background checks being done on them, as well as criminal checks if it's relevant to the position for which they're applying for.
But just to be clear, there would still be limitations, Samir. You couldn't just ask questions that didn't relate to the inherent requirements of the job.
Sure, that's correct. The information that you're seeking must be relevant and must not be excessive. Yes, that's one of the other. So while there's consent, you have to still comply with the other processing conditions of POPIA. So basically, those are the questions that we deal with job applicants. So that's the pre-employment phase. When a person is employed, then you process their personal information for various reasons. And currently, one of the questions that we are being asked is, in the event of interception and can we intercept their communications in the workplace? In the event that, for example, we suspect that they may be involved in some type of misconduct. And the answer to that is, in South Africa, we do have legislation, it's commonly referred to as RICA, that entitles employers to monitor or intercept the communications of employers. You can do that with the employee's consent, or in the event that the communication is in respect of work-related or business-related, it's business-related or work-related. And if the person's party to the conversation. Now, for the purposes of POPIA, we say that employees must be made aware of this, so consent must be obtained. If consent is not obtained, we advise that contracts of employment have a POPIA clause, also have a clause that deals with the fact that employees may intercept your communication, that there are policies in place for that. And the ground on which you'll rely on, as apart from consent, is to protect the legitimate interests of the employer.
Again, are there limitations? Let's say I have emails and 80% of them are business, but there's a whole lot of personal emails. Can my employer trawl through my personal emails? Is there a limit to that?
So while the employer may stipulate in an employment contract clause that they are entitled to intercept and go through your personal emails if they are sent via your company-related email, email address. In terms of POPIA, you cannot process or have access to personal information unless there's a legitimate purpose for it. Yeah. Another example, just in the workplace, is alcohol and drug testing. We see a lot of that recently, where employees are questioning why should they be subjected to such testing. Now, in terms of it depends on the nature of the position as well. There's an obligation also on employees to provide a safe workplace and not place others at risk. So there's a legal obligation for employees in certain instances to subject employees to drug and alcohol testing. Also the type of position. So a person could be operating, for example, a forklift, and there's needs to not be under the influence of any drug or alcohol. So therefore there is an obligation on an employer to protect his legitimate interests, as well as the legitimate interests of other employees, to ensure that and to conduct those tests. Again,
I see some constitutional court in South Africa ruled that it wasn't it's not illegal to make use of marijuana in your personal space at home. How has that impacted on POPIA and the workplace?
Yeah, in your personal space you can make use of it, but in the workplace it's precluded. And if you are under the influence, or if you are test positive marijuana in the workplace, if there is a zero tolerance approach policy in place, then the employee can be disciplined for that, and cannot refuse being subjected to a test, because that will be a reasonable and lawful instruction.
Okay.
Yeah.
And you've dealt with, is there any post-employment issues that arise?
Yeah, so in terms of South African legislation, you have the Labour Relations Act, the Basic Conditions of Employment Act, Employment Equity Act, all require you to keep information pertaining to your employees for a certain period of time. And therefore, employees need to be aware that subsequent to their termination, that you are entitled to process such information. One question that comes up often is references. So can you as an employer give a reason for termination for a former employee? And the advice that we've been given is that in terms of the law, all you're required to provide is the fact that the employee was employed by you on this date and it left your employment on X date. The reason for termination is not to be provided. But if you have the consent of the employee, which you may get during the exit interview, or maybe the employee may phone you and say, please provide, I've given your name as a reference, please can you provide information as to my performance and the reason for my leaving, then you're entitled to do that. So don't offer information to a prospective employer of a former employee regarding the reason for termination without the employee's consent. That's my advice to
Now, my recollection, just to end, that there's been a few enforcement acts by the regulator, particularly in respect of the Department of Justice and the police. They've taken on the public sector quite strongly in South Africa, as I recall.
Yeah, recently they've taken on DISCEM as well, but that's just an enforcement notice that has been issued. With SAPS, South African Police Services, the information regulator issued an enforcement notice to them, to the SAPS, for sharing the details of rape victims with other SAPS members on a WhatsApp group that had no reason to have access to that info. They directed that apologies be issued to the rape victims in terms of the enforcement notice. The information regulator directed that SAPS should do that. And
just to clarify, SAPS is the South African Police Service.
Yes, yes. And to that they investigate the members of the South African Police Services, share the info, and include training on POPIA for everyone, which they complied with, and that was the end of the matter. But with the Department of Justice, there was a breach of their, there was a security compromise in terms of their malware, and what had transpired there is information regulator issued an enforcement notice to say to the Department of Justice to do a few things within 31 days. One of it was to renew its various licenses for the software, and to investigate and take disciplinary action against those employees who could have who failed to renew the licenses within 31 days. The Department of Justice didn't comply with that enforcement notice within 31 days, and as a result, the information regulator fined it's 5 million rand.
All right. Well. Thanks, Samir. We're going to now move on to some of the other jurisdictions. We'll start with Patricia. Hi, Patricia.
Hi, Brian. So,
Patricia, Samir has given a very comprehensive review of South Africa. She's done it intentionally so that we can look at the differences, and maybe you can just highlight some of the differences. But before you do that, one of our viewers has a question for Ghana. And the question is that they find it very difficult to have any engagement with the Data Protection Commission in Ghana. Do you find the same? And she's referring to in terms of incidents. It's not what process do you follow. I'm sure if she contacts you, you'll assist her. But is there a problem with engaging with the Data Protection Commission in Ghana?
No, there's no problem with engaging the commission. We have a very cordial relationship with the commission. And so we're able to contact them by email, by phone calls. We visit them sometimes. And so we haven't had any notable issues in relation to reporting data breaches or compromises in the past. And we are happy to assist if the client reaches out to us.
Thanks for that. Now, if we look at Samir's comprehensive review, where would you see some differences in Ghana that you'd like to highlight in a couple of minutes?
Okay, so very similar to Ghana, pre-employment stage, during employment, and post-employment, it's practically the same. I'll only want to point out the issue about recording secretly, whether it's a phone or a video recording. You have to have the consent of the individual or the employee, and if you do not have the consent, our courts have pronounced on that, that is an infringement on the privacy of the individual if you do not obtain their consent and you go ahead and do a private recording. So I wanted to highlight that. But in respect,
can I just clarify, does that mean even between you and me? So if I'm talking to you on a video call, and obviously we have consent to this today, or a telephone call, and I just happen to record our discussion, and am I infringing your rights of privacy in Ghana?
Yes, you are, if you do not obtain my consent to record.
Well, that's a major difference, South Africa. If it is inter partes between two individuals who are discussing, if there was a third party, they would need the consent. So that's quite significant.
Yeah.
And anything else, Patricia?
From Ghana, no, in relation to what Samaya mentioned, I believe we'll get into the other things, but for the pre-employment, during employment, and post-employment, maybe I should add some of the things that employers do when they have their employees in respect to data protection. And so you have to, if you have a policy, a data protection policy or data privacy policy, it will be good for the employees to know that you have that policy, and it will be good for you to train your employees on the policy and what it contains and the repercussions if they breach the policy. So that's one thing I wanted to mention. Apart from that, everything falls on same as Ghana.
Excellent. I have a question from a viewer on recruitment policies or recruitment platforms and sourcing of CVs. If that viewer could just make it clear what jurisdiction they're referring to, because you could get up to 7 different answers on this webinar today. Thank you very much, Patricia. If we could go to Dennis in Mauritius briefly. Hello, yeah, Dennis.
Thank you, Brian.
Dennis, if you could just tell us where the differences are, please.
Yeah, so as far as Kenya is concerned, I believe the position is quite similar to what Sumaya has highlighted in South Africa. The only difference that I'd like to highlight similar to Ghana is that interception of communication in Kenya would be prohibited, not just under our privacy laws, but under our Computer Misuse and Cybercrimes Act. It would constitute an offense, and that's punishable under law. So that's not something that we would recommend. So in the event that there is a need for the employer to have access to information contained in a device owned by an employee, it would be prudent for the employee to be informed of that particular need, and for the employee to actually provide consent to avoid not only being in violation of the Data Protection Act, but also the Computer Misuse and Cybercrimes Act. Otherwise, in terms of pre-employment, during employment, post-employment, the situation is quite similar to both Ghana and South Africa.
Do you in Kenya, do you generally in Kenya provide references? Is there an issue with references post-employment?
Yeah, similar to South Africa, we do provide references, but it's not recommended to disclose too much information or details regarding an employee's employment, reasons for their termination, and so on and so forth, because you might find that you're disclosing information that could constitute personal data. And Kenya is quite a litigious society, so we are very, in terms of protecting our rights, we're very aggressive about it. So we wouldn't recommend a situation where disclosing more than they have to unless the employee's consent or the former employee's consent has been provided.
Thank you very much, Dennis. Let's go to Mauritius now, Harry.
Hello.
Harry, thank you. We're interested in any of the key differences between the jurisdictions that we've discussed.
We're quite aligned with the other jurisdictions, Brian. what Sumaya has highlighted is quite the same with what obtains in Mauritius. Perhaps one matter which we could highlight is that after the employment relationship, how long may records of employees be retained by the employer? In Mauritius, this answer may vary depending on the situation with the employee. Did the employee leave the employment in good terms, or is there an impending dispute? If the employee left in good terms, then there are two periods which may trigger. Either the one under the Workers' Rights Act, i.e. 3 years, or the one under the tax laws, if there are documentation pertaining to tax, then the employer would be entitled to retain those documentations for a period of 7 years. Now, if the employee leaves in bad term and there is a dispute, the employee is entitled to enter his dispute in court within a delay of 10 years. Then the employer will have to retain, or at least he will be entitled to retain the documentation either for 10 years or whichever longer period as would the determination of a case ends.
Thank you. Moving now to Ray Wood of Namibia. Ray Wood, any distinctions of consequence with that you want to highlight with what has gone before?
Yes, Namibia is cut and paste similar to what South Africa does. We borrow generously for the reasons that I have mentioned previously, but the only maybe differences that I can highlight is consent would not be necessary or would not be necessary in certain circumstances where the legitimate interest or the reason for collecting of data speaks to maybe national security or the defense or public safety. Then in those circumstances, it outweighs in the individual interest and it can be collected. And I'm speaking now specifically pertaining to issues of criminal records and so on, and health status and so forth. And also in instances where prior to employment, where an employee applies for a specific position and that position requires security checks, then it is deemed to have consented by having applied for that position. There is no specific.
Yeah,
yes,
this
Brian,
Ray Wood is what we're used to by way of a sort of constitutional balancing act between competing rights of privacy on the one hand and the rights, other rights in the Constitution, that no right's absolute and that one has to balance the two. Am I right, or am I missing something?
No, you spot on, Brian. That's exactly what I'm referring to. That yes, you can collect, but then you have to have that balance between the interest of the individual and whether it's public interest or safety of the country and so on.
When do you anticipate that the legislation is likely to come into force and effect? Because that's going to change the Namibian landscape to some extent.
That's correct, Brian. It will change the trajectory of the space, but unfortunately, I would not be in a position to say, because it's motivated by political will, and it's a draft that has been in circulation for a while. There seemed to be no hurry on the political end to get it before for it to be enacted, basically.
I think South Africa took something like 8 years, so maybe you could see if you can beat the South African record.
Yes.
Thank you very much,
Thank you, yes.
Ray Wood. And just then moving to Rwanda and Jean-Claude. Hello, Jean-Claude.
Hi, Brian.
Is there any specific issues in Rwanda that you want to highlight that may be different from some of the other panelists' exposition?
There is no specific issue with regard to South African Data Protection Act. save for if an employer process the data protection of employee without their consent, he may undergo some sanctions. He may even be sued for damages and sanctions under Data Protection Act. Thank you.
Thank you, Jean-Claude. Just back to South Africa. Samaya, I'm going to give you another bite at the cherry, but before doing that, I have a question from a viewer as follows, that I think just from the timestamp relates to South Africa, because you were speaking at the time. It says, when using a recruitment platform to source CVs of a range of candidates, identifying your shortlist and proceeding with those, who maintains the responsibility to protect all the candidates' personal information on the recruitment panel? On the recruitment platform, sorry.
Yes, so it would be the owner of that platform. So who runs that platform will have to have this consent forms or some sort of agreement with these job applicants to say that they will be processing their personal information in the form of CVs on this platform for a certain period of time, and that the obligation lies with them to update the details as and when it changes, and to also get consent or from them that their CVs may be further processed by sharing it with people who access that platform. So
I think the viewer, Samaya, was probably alluding to the possibility that there may be some derivative liability of the platform user in using this information that's been obtained contrary to privacy regulations. Any comment on that?
Yeah, there can be an agreement, or sometimes when you have access to that website, they will have a list, a tick box exercise of undertake not to use this information just for recruitment purposes only, and not share it forward it on to others and things like that. So that can be something that a website should have to protect its users against, so that they comply with POPIA and to protect the information of those job applicants.
Now, do you have anything arising out of what's been said that you want to highlight? So I think I've dealt with most of the questions as we've gone along, so this might be your final opportunity.
Yeah, just what Harry mentioned on retention of personal information. There are various pieces of legislation that provides timeframes, but in terms of the Companies Act, Section 24, it does provide a period of 7 years in relation to subject to a longer period provided for in any other public regulation. So we would advise clients generally that the 7-year period is a safer route to follow, unless there's a legislation that provides a longer period.
I know some companies, Samaya, in the US and elsewhere, adopt a very strict policy in respect of the retention of documents. They retain them for the statutory period, and then they destroy them. And the reason is that it can assist them if there's some other liability, that those documents are no longer in existence and they are not legally required to maintain them. Any comment on that? Is that something that happens in South Africa elsewhere?
Yeah, that's what POPIA also provides for. At the end of that period, the information should be deleted, destroyed, redacted. Yeah.
So you shouldn't keep it. You should take active steps to delete or remove it.
Yes.
Destroy it.
Yeah.
Okay. Well, thanks very much, Samaya. We just move finally to Rahima in Uganda.
Yes. Yes, Brian.
Hi,
so
Rahima. Yeah, just really looking at differences. Anything of significance in Uganda?
Yeah, so maybe just to highlight that our law, our DPPA does not have specific regulations when it comes to data privacy in the employment context. Now you'd have to apply and interpret the regulations in the best way you can to the different situations that have been highlighted. But the analysis would lead to the same conclusion as has been highlighted from the South African perspective. So in all the different contexts, pre-employment, during employment, and then post-employment, the analysis under Ugandan law would still come to the same place as South Africa.
Okay, well, thank you very much. Just remains for me to thank all the panelists. I think this was a very useful exposition. I think it's manifestly clear that the similarities with GDPR are probably greater than the distinctions. But like most things in life, it's the distinctions that are likely to cause some challenges. In respect to the reviewer that mentioned the African Union and the possibility that that should have been done at a continental level, I couldn't agree more with you. I think that would be opportune, and it's really important to take discrete, specific advice from people in country who understand the law in those countries and not just rely on general principles, because this is reputational damage and it's also part of your ESG compliance. What we have done for those listeners who've shown us some forbearance and have gone through this whole webinar, we put together a summary, which is really the speaker's notes. We've got a little bit of minor reparagraphing to be done. It should be ready in the next 48 hours. And for those viewers who would like to contact the organizers of this webinar, we will gladly send you a summary of the law in respect of GDPR and privacy in all 7 jurisdictions that we have covered. So thank you very much. There will be another one of these webinars in about 8 weeks' time. The topic still has to be finalized, and thank you very much for joining us today. Just before you do go, I see one stalwart viewer has got one final question. Let me put this again. It's not entirely clear. Oh, it's Papia. So Samir, you get the last word. The question is as follows. Is it required for an employer to seek consent to record employees' conversation for proof as evidence for disciplinary proceedings, especially where an employee is insubordinate?
So in terms of, I take it it's a discussion between a line manager and an employee where the line manager records a conversation. And it's, used for the purposes of insubordinate. Yes, it can be recorded. That will be my simple response to that. You are a party to the conversation in terms of RICA. It is related to you, to work. It is a work-related thing. And obviously, to comply with the other lawful processing conditions, you would have to, still let the employee know that you have recorded. This is what the purpose for it, why you recorded it, where it will be used, and
Well, let me just finally, maybe I'll have the last say. Have a follow-up employment law question. It may be lawful to record because it's party to party. You're party to the discussion in South Africa, and we know that you can record. So it's not illegal. But might it be insubordinate or grossly inappropriate or a breach of the company's policies and procedures for me to come into my senior's office and start recording discussions without the senior, maybe in support of a constructive dismissal claim or the like, without that person knowing? Is there a chance that it might be actionable from an employment law perspective?
So
it's not illegal, but is it appropriate?
It's not, no.
So I just want to, because we've come across that, and I want to just make it clear to viewers, there's a difference between lawfulness and illegality, and conducting oneself appropriately in the workplace. So with that, let me leave you and say thank you very much for joining us today. And we hope that you'll join us on our next webinar. All of the panelists, we'll be circulating their contact details, emails, so you can contact them directly. Thank you very much for joining us. Bye-bye.
Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.